Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and I'm joined today by guest contributor, one of our interns, Ore Shoyinka. Welcome, Ore.
Hello, everyone.
Now, you've been with LLG 6 months. How are you finding it? Did you enjoy the spring conference?
Yes, I'm enjoying my time at LLG. Working closely with the board is a pleasure. They are a very proactive group of people. It was lovely meeting most of them at the spring conference, which I thoroughly enjoyed. It was the first time being exposed to an environment like that, a room full of engaged, knowledgeable, and fun individuals. My highlight was definitely the karaoke. I sang my heart out.
Karaoke is definitely a favourite with most of our members, and I know that Jack really likes to do it as well, so I'm pleased you had a good time. But let's get on to the business of the news. Obviously, we have the general election on Thursday. Good luck to everyone involved with that. But what else caught your eye from the bulletin last week, Ore?
Well, yes, Helen, the bulletin is packed full of election material. I want to look at what is going on in the post office inquiry, because it heard from a long-awaited witness in the form of Gareth Jenkins. Now he is the Fujitsu engineer whose testimony helped convict a number of postmasters. Mr. Jenkins gave testimony that in October 2010, he had emailed a draft witness statement to prosecution lawyers Warwick Tatford and Janelle Singh and investigator John Longman. Mr. Jenkins used the same template as he had for all previous witness statements. He specifically asked for their feedback as to whether it was correct in terms of the approach and style. Jenkins says in his written statement, and I quote, "No one suggested that I needed to add any sort of expert declaration to it." Mr. Tatford made comments on this draft. He appeared to want me to make some points more strongly in favor of POL than I had done before. In particular, he wanted me to say that it looks as though Mrs. Misra had stolen money rather than that it was incompetence. Jenkins advised that he went on to refuse this particular request. He said he felt uncomfortable at what he was being asked to do and accepts now it was probably totally inappropriate. So what else did we learn? Well, we learned that Mr. Jenkins felt like part of the prosecution team because that was how Post Office treated him. That it did not occur to him at the time that he was expected to set out in detail relevant experiences and duties to the court as would be expected in a defense expert witness statement. And that Jenkins believed he was, and I quote, basically doing what I had been asked to do, which was to comment on the report, and then it was suggested that it was presented in terms of a witness statement. So that's what I did. Helen?
Thanks, Ore. Well, that content was taken from an article in the Law Gazette, and the Law Gazette is actually doing really great coverage of the Post Office inquiry if anyone wants to follow along in a kind of summary and succinct fashion. Now, there are so many worrying moments coming out of the Post Office inquiry of relevance to our sector. The way in which the prosecution took place is particularly concerning. It's fundamental in all matters, as we know, that a witness statement is produced in the witness's own words and from their own knowledge. The fact the lawyers asked Jenkins to change his statement is worrying. It should be remembered also, and this was reported in The Guardian, that Jenkins is part of a Metropolitan Police investigation into possible perjury and perverting the course of justice. As such, Jenkins held privilege against self-incrimination whilst giving testimony to the inquiry. Now, I think you've identified a matter for property lawyers, I think, Ore.
Yes, Helen. The government have issued guidance on the execution of deeds with reference PG8. Specifically, this is advice on the execution of deeds that are to be submitted to HM Land Registry and is aimed at conveyancers. It is all relevant, but the most relevant part appears at Chapter 7, which gives guidance on the execution of deeds by local. Sets out that in addition to the default forms of execution set out in execution of deeds by other corporations incorporated in the UK, many local authorities delegate authority to execute deeds and documents to various senior officers. Principal councils can avoid having to lodge evidence every time by emailing it to local authority execution at landregistry.gov.uk, where it can be recorded centrally. When executing deeds, the name or office of the signatories, as appropriate, should be included so that the registry can be sure it is correctly executed. It notes that many local authorities are currently unable to arrange for execution of deeds in accordance with the established special arrangements with HM Land Registry. A number are amending their constitution to authorize alternative methods of execution. Until further notice, they state that they will accept execution where a local authority also certifies that it is, under its constitution, able to validly execute a deed other than in accordance with their special arrangements. It further states the following certificate must be lodged with the application, signed by an individual conveyancer employed by the relevant local authority, and stating that the deed has been duly and properly executed in accordance with the council's constitution. The certificate must state, I, the name of the conveyancer certifying, a conveyancer employed by the name of the authority, certify that the transfer or other deed submitted for registration, dated the date of the deed, is made by the authority of the council and has been duly and properly executed in accordance with the council's constitution. Helen?
That's very helpful, Ori, and it's not often we concentrate on property law, so I hope that our property lawyers appreciate that focus. Now, in other news, I took a look at a send case. It's the case of Hampshire County Council and GC 2024. This is an important case. It's described by Judge West in the upper tribunal in his decision as a test case, and it concerns a family who moved to Dubai for 2 years because the father was deployed there as part of his naval service. Now, the facts of this case are as follows. The local authority ceased to maintain their child's EHC plan pursuant to Section 45 of the Children and Families Act 2014 on the basis that the family were no longer in its area. There are requirements set out in the Special Educational Needs and Disability Regulations 2014 in relation to consultation before local authorities take such decisions, which in this case the local authority had not complied with. By the time of the hearing of the appeal to the first tier tribunal, the family were stationed abroad but were due to return. The judgment held that the provisions of Section 45, subsection 1 bestow a discretion on the authorities to cease to maintain an EHCP, not an obligation on it to cease to maintain it. As the Department of Education itself observed, rightly in my judgment, see the email of the 25th of April 2022, which is contained within the judgment, quote, regarding Section 45 of the Children and Families Act 2014, the Secretary of State's view would be that under this provision, local authorities have a power but not a duty to cease to maintain an EHC plan, and the SEND Code of Practice is consistent with that position. You can find that at paragraph 247 of the judgment. It goes on, moreover, by virtue of Section 42, subsection 5 of the 2014 Act, the Council was not obliged to, quote, secure the specified special education provision in the HCP if the child's parent has made Hampshire County Council suitable alternative arrangements. Mr. Lyon contended, and the judge accepted, that it was for the local authority to satisfy itself that suitable alternative provision had been made, and the council in the present case had not done so. Further, that the council had precluded itself from considering and answering the question of suitable alternative arrangements, firstly by contravening Regulation 31 of the 1996 regulations by failing to consult with the parents, and secondly by erroneously stopping its analysis prematurely at the mere fact that the child had been transferred to Dubai. It's a really incredibly important judgment. It's one to take note of. An education specialist rather, should make sure that they brief their relevant departments in relation to it. Now, Ori, I believe you've taken note of an article regarding local plans.
Yes, that's right. From the local government lawyer website in an article by Adam Carey. Councillors at Wrexham County Borough Council have obtained permission to appeal a High Court order which forced the local authority to adopt a local development plan, also known as LDP, that councillors had previously voted against on 2 separate occasions. Court of Appeal will hear the appeal against Mr. Justice Ayres' order in a hearing on 15th of October 2024. Councillors had previously refused to adopt the LDP on 2 separate occasions in late 2023, leading to developers pursuing a judicial review challenge. IJ ultimately ordered the council to hold an extraordinary meeting to adopt the plan in December 2023 as part of the judicial review proceedings. Councillors adopted the local plan that same month, following a warning from Wrexham's monitoring officers that they could face contempt of court charges and a prison sentence if they defied the court order. But the group of councillors behind the appeal claimed the circumstances undermined democracy. In a statement on their Crowd Justice page, the group said, the LDP, as it stands, is not in the best interests of Wrexham and its people. It goes on to say, that's why we're seeking to challenge this fundamentally unfair and undemocratic situation via a court review of the council's decision to adopt the plan by bringing proceedings through the planning court. As a result of the permission for appeal, the LDP was paused until the hearing is concluded. The Court of Appeal's judgment may also be significant as it could see Wrexham recoup 100,000 in costs awarded against it. Helen?
Well, that's really interesting, and I'm sure all planners' eyes will be pinned on that Court of Appeal hearing. And we will pick it up on the podcast when judgment is given following the hearing date. I don't know the date yet. There'll probably be a little bit of a delay on it, but when we do, we will try to flag it up. And finally, for me, sticking with planning, the Royal Town Planning Institute have said that planners will be paying close attention to the next general election because the homes, infrastructure and services communities need depend on politicians who understand the power of proactive planning and can use it to lead. In their Planifesto, which I rather liked, the Institute states that effective political leaders are fundamental to our country's planning systems. Their vision drives our planning systems, and their judgment makes fair decision making possible. Now, at the next election, the RTPI are calling on political parties across the UK to support planners and realise the economic, social and environmental potential of planning. And to do this, it says that the next UK government should fund councils to deliver high quality planning services, explain where manifesto promises will be delivered, strengthen local plans to empower communities, work with local leaders to avoid piecemeal development, and plan for net zero. So let's get through the election and see what the next government intends to do with planning. They'll certainly have a number of pressing issues to address, some of which will need to be addressed with speed. And on that note, you can read more on these items by going to bulletin number 23, available on the LLG website. And don't forget, you can now follow us on Spotify by searching for the LLG Grapevine podcast. And if you want to learn more about microdevolution, take a look at the vlog I did with Ian Morris last week. He's the town clerk at Spennymoor Town Council and board director of the Society of Local Council Clerks, and very academic in his approach to this. It's fascinating stuff and packed full of local democracy possibilities. So it's goodbye from me. Thank you for joining me, Ore.
And goodbye from me too. Thank you.
Have a good week, everyone.